Okay. Is Mr. Daniels with us?
Starting the recording.
Yes,
So, yeah,
Okay, good morning. We should be starting momentarily.
I'm still reading.
Yeah.
Mark, apparently you and I had the same issue that it went into our junk mail. I saw it at 7:45 this morning.
got you. Yeah, forgive the attire, Mr. Krillo, because I'm obviously going over to Supreme Court.
Oh, yes. Well, I mean, ordinarily that would be the appropriate attire.
Well, I mean, not wig and gown, but
Yeah, yeah. Okay, we are going to be recording, so I'm going to activate the recording now.
certainly, thank you.
Okay, good morning, everyone. We are appearing in the Court of Appeal for Bermuda for Civil Appeal number 11 of 2019. Keimon Lawrence against HSBC Bank Bermuda Limited. This matter is for handing down of judgment, and the proceedings are before my Lord President, Sir Christopher Clark, and Justices of Appeal, Dame Elizabeth Gloucester and Justice Anthony Smelly.
Well, good morning. Thank you for being here promptly and on time. For the reasons contained in the judgment which I now hand down, the appeal is allowed. Now, there are a number of potential consequentials that arise. The first of which is that, as appears from paragraph 46 of the judgment which I've just handed down, it seems to us, subject to any further argument, that the bank ought to undertake not to sell the property until further order of the Supreme Court. Is the bank prepared to give that undertaking?
Good morning, my lords and my lady. I must say I received the judgment at about 7:45 this morning, and
dear.
I've made my way through it, but I haven't had the opportunity to take instructions. What I will say is that I think it would be certainly my advice to the client to give such undertaking. So I'm not exactly sure whether to
Yes.
crave your
Well, I think
indulgence to take such instructions, but it certainly would be my advice to the bank to give.
Yes. Well, I think we can leave it this way. I'm going to ask that an order be drawn up in this case so that it's entirely clear what we have determined. The first paragraph will allow the appeal. I hope that it will be possible that the order will recite an undertaking from the bank not to sell the property without a further order of the Supreme Court. And I give notice, as is apparent from the judgment, that if such an undertaking is not given, the court, unless persuaded to the contrary, I can't at the moment think how it could be, will simply enjoin the bank from disposing of the property, pending an order of the Supreme Court.
Yeah, certainly understood, and I'm happy to take those instructions as soon as I can and revert back to the court.
Yes, thank you very much. Next item on the program, there is, of course, an outstanding judgment against the appellant. And it would seem to me, in the light of our decision, that there should be a stay of that judgment until further order of the Supreme Court.
Yes,
because whether or not the judgment is valid against the now successful appellant will depend upon the outcome of a determination as to whether he was unduly influenced by his father.
Yes, my lord.
Right. Well, that seems to me that ought to go into the order. And then there is the question of costs.
Apologies, I'm just frantically taking notes here. My lord, I must say, I guess without the benefit of a great deal of time to take instructions or consider this, but I would like to suggest that the issue of costs potentially be reserved in this matter. I think it's going to be, this is an important step that this court has made this determination, but unfortunately, I think there's several subsequent steps that have to take place. And I think until we have a greater picture of where we land, it's going to be difficult to have a finding of sort of costs in favor of the appellant at this stage. The other point, much more minor point that I would make is that there were a couple of points, albeit not very many, but a couple of points that the appellant raised which were unsuccessful. So my submission is I think at this stage it would be appropriate for costs to be reserved and to be considered in light of the entirety of the proceedings, as there's bound to be further proceedings required in the Supreme Court.
Are you talking about the costs both here and below, or what?
I think both here and below, yes.
Right. Okay. Mr. Daniels, what have you got to say?
Yes, good morning, my lords and my lady. Respectfully, in ordinary course, I think that I would ask for costs to be awarded in favor of the appellants in the cause. But I do appreciate the point that my learned friend has made in terms of the fact that the argument must proceed still before the Supreme Court. And I must confess that I'm not entirely I would suggest, though, at this stage that it is appropriate that costs can be ordered in favor of the appellant based on the appeal being allowed, notwithstanding that there were some points that the court did not agree with. The overall ethos of the argument was sustained before the court, irrespective of the fact that there are matters that remain due to be determined before the Supreme Court, my lord.
What about the costs below?
Respectfully, the costs below, and that's where I understand where my learned friend's coming from, but because of the ultimate outcome of this case, I think that there's no cost order that's been made in the court below, and so therefore my respectful submission would be that this court order costs from the Supreme Court as well as the Court of Appeal in favor of the appellant at this stage, notwithstanding the remaining items that would have to ultimately be determined, which could be settled at a subsequent time.
Sorry, I want to make sure I'm following you. So at the hearing in front of the Chief Justice, no order was made?
Not at this, sorry, an order for costs has, I have to be clear. I don't think an order for costs, yes, order for costs was made down below, if I'm correct. Forgive me. I know that it had not been settled, I should say, by the Supreme Court, what costs were, if my memory serves me correct.
My recollection, my lord, is that the Chief Justice indicated that he would be happy to hear the parties as to costs. We had made an application to be heard, but that was actually to be heard at the same time that this appeal was initially listed, and got kicked into the long grass, as it were. So there hasn't been a determination as to costs. I mean, certainly.
Oh, I see. It's not
that the bank was successful.
It's
below,
not that the Chief Justice has made no order. It's just that the hearing as to what order he should make has not taken place.
That's absolutely correct, my lord. Yes.
Yes. Right. So what are you asking for, Mr. Daniels?
I was asking for this court to make the order for costs, respectfully, my lord.
I see. Okay. Ms. Hale, there may be a distinction, not necessarily, but there may be a distinction between the costs of the appeal, which could be said to be necessary on account of the fact that the learned Chief Justice had, in the light of our decision, approached the matter on an erroneous legal basis, and the costs below. It could be said that exactly the same situation arises in relation to the costs below. But what is there anything you wish to add in relation to either the costs of this appeal or the costs below?
I think not really, my Lord President.
Okay.
I think I'd maintain the same position that I think we really need to consider, while this court could certainly quite reasonably make an order as to costs as it relates to these proceedings. I think we do need to consider the entire position, because there are certainly going to be subsequent proceedings. So same point really that I made earlier.
Okay. Well, I think we will retire to, unless anybody wishes to make any other observations, we will do the equivalent of retiring, that is to say, go to a breakout room in order to address our mind to the question of costs.
I'm grateful.
Can we do that? Yes.
So Christopher, you haven't left the main
Oh,
area.
haven't I? Oh, I'm so sorry.
That's fine.
Well, wait a moment.
You should have the leave
What
button.
it says, well, what it says is leave meeting.
No, you don't want to leave the meeting.
No, I don't want to, but a breakout room. Oh, I see.
So Christopher with us?
Mr. Coelho, apparently you have to start my video.
Oh, axe to start with. There you go.
All right.
Okay. Mr. Daniels, just so that you know, you're mute. So if you
Right. Are we all here? Yes, we are.
Yes.
Well, the order that we propose to make is that the appellant, Mr. Lawrence, shall have his costs of the appeal and the costs of the hearing on the 28th and the 29th of October. But the other costs of the action are reserved to the judge. Now, Mr. Daniels, I look to you to draw up an order in consultation with Miss Hayworth
Shall.
to give effect to what we have decided.
I shall, my lord.
Thank you. Well, we're most grateful to the advocates on each side for their helpful submissions.
Thank you, my lord and my lady.
Thank you.
Thank
We
you.
will break out again if we may.
Yes, my lords. Have a great day.
This concludes the June 2020 session of the Court of Appeal.
Thank you very much.
Thank you
Thank
kindly.
you.